Marco, thanks a lot for the kind invite, also for the translation of the paper. It's a real pleasure to be here, to be with you, virtually, at least. Hopefully next time I will be there physically. I will be talking about responsive enforcement. Before I start, so you told me that my speaking time will be around 40 minutes, so hopefully I will be within time. Feel free to jump in and interrupt whenever you want. I don't want this to be a monologue, so just like jump in whenever you have any questions or comments. So let me just share the slides here. So let me start with the roadmap of what I will be talking about today. So I will be introducing the idea of responsive competition law. What is this? Why should we care? And how we could actually make competition law, which is already somehow responsive, more responsive. Then I will be focusing on responsive enforcement, which is just a part of this theory. And then I will be taking you through some case studies, some examples of what I would consider successful or a failed attempt to behave responsibly. And then we'll close up with some key takeaways. So let me start with a conventional, the conventional actually view that there is a categorical line between competition law and regulation. According to this kind of framing the issue, we tend to consider competition law as a passive way to interfere and intervene in the market. We consider that competition law is about ex post assessments and is about punishing anti-competitive behavior, harmful behavior when it has occurred. So according to this line of thinking, competition law is not about shaping the market or engineering market outcomes, but about restoring the competitive process when a harm has already occurred or is likely to occur. And from this point of view, competition rules are perceived as prohibitions, as don'ts. You shall not abuse your position. You should not restrict competition, etc., etc. And there is an implicit assumption, which I will make clear, I will make more explicit, that the sole purpose of competition law should be consumer welfare. And why is that implicit assumption behind this categorical line between competition law and regulation? Because if we perceive competition law as an exposed way to intervene in the market only when there is actual harm, then we need to perceive somehow this harm. And the consumer welfare standard, with its output and price-based related metrics, offers a way to quantify this kind of harm. So this model that draws a categorical line between competition law and regulation entails that also competition law enforcers will be behaving as police, right? So when there will be an actual harm, they will be intervening in the market. They will be justified to intervene in the market. Otherwise, they should refrain from action. And this is where also consumer welfare the consumer welfare standard comes in, because it offers a quite, at least ostensibly, objective way to quantify damage. And on the other hand, this categorical line between competition law and regulation perceives regulation as ex ante, as a heavy-handed tool to restructure markets, and as something that can be prescriptive, so prohibitions, but also prescriptive. Tell to the market players what to do. And also, it is a common belief that, of course, regulation can pursue several interests, public interests, and goals, whereas competition law is to be focused solely on consumer welfare. So if we frame the distinction between competition law and regulation in that way, there will be a direct normative implication, a direct policy implication. What would that be? On the one hand, we have a pure, like consumer competition law, a pure antitrust, which is supposed to intervene only when we have actual anti-competitive effects. And this is also very well tied with what I call the crime tort enforcement model. So competition authorities are actually police. Then there could be a hybrid model where, for instance, authorities intervene when there is actual harm, but also when there are potential anti-competitive effects. And this could be as a compromise, let's say, between the more light-weighted approach and the more heavy-handed regulatory approach, a compromise that is based on, for instance, a fear of under-enforcement. So we relax a little bit the standards and we intervene not only when actual anti-competitive effects exist, but also when potential anti-competitive effects are likely to arise. And then there could be another model of applying competition law, the so-called regulatory model. For instance, enforcers behave prophylactically and are overly cautious and engage with market behavior also in order to restructure the market or anticipate potential harms to competition. And according to this line of framing, this way of enforcing competition law is problematic, is an aberration. The hybrid antitrust is a compromise, but the regulatory antitrust is an aberration. But I argue here that this framing, which is very much embedded in our discussions, is problematic. Why? Because it downplays the embedded responsiveness of competition law. It caricaturizes actually the distinction between competition law and regulation. Let me explain that. So modern competition law seeks to protect effective competition, and this is an essentially contested concept. So there is reasonable disagreement with regards to the concretization of the concept. So from this point of view, competition rules could be perceived not simply as prohibitions, what not to do. You should not restrict competition. Sure, but what does this mean? If we take into consideration that the purpose of the law is the protection of the competitive process or of effective competition, and this is an essentially contested concept, then we will see the rules, we will perceive the rules as a mandate to competition authorities to exercise discretion, of course, within the limits of the law, of course, susceptible to the judicial review of the courts, but exercise discretion to concretize this abstract and open-ended concept of effective competition. So this doesn't really fit to the model that draws a categorical line between competition law and regulation. Then the second reason why I'm not convinced by this distinction is an observation that has to do with how the law actually operates. So if we look at EU competition law, but similar things apply also to US antitrust and in many other competition law regimes, we will see that authorities and also courts, right, do not intervene only when there are actual anti-competitive effects, but also when there are potential restrictive effects. This is already included in the restrictions by effect category. And of course, when there are restrictions by object, namely when there is behavior that reveals in itself sufficient degree of harm. So is that regulatory? So competition law is already regulatory. So if we frame the things, if we frame the competition law versus regulation distinction on those terms, some important concepts will not be grasped, right? Such as restrictions by object. Another example is abuse of dominance. So it is established case law that abuse of dominance can occur not when we have actual anti-competitive effects, but when the conduct of a dominant undertaking is able to foreclose, has the ability to foreclose the market. An example is, for instance, predatory pricing. Simply pricing below a measure of cost can be considered abusive, regardless of any recoupment. So is this a line of case law also regulatory? And then, of course, if we take the merger control regime, my point here is obvious. In merger control, we are looking at the crystal ball, and we are, of course, with economic evidence, right? And market simulation analysis, we try to predict future behavior. We try to predict whether the transaction is likely to significantly impede effective competition. So to a great extent, competition law is already what some call regulatory. What I will try to convince you here is responsive. And a last point that can highlight why competition law is already to a large extent responsive has to do with the existing enforcement apparatus. So if we actually look at the tools the legal mechanisms that authorities have at their disposal to apply the law, we will see that they do not have only punishment and deterrence tools. They are not only police officers. They have a wide array of multiple tools of varied intensity and of different features that would allow them, and actually does allow them, to calibrate and recalibrate their intervention. So on this basis, I'm claiming that competition law is already, to a certain degree, responsive. And let me make it clear at this point, when I talk about responsiveness, I refer to the ability to adapt to changing factual and normative circumstances, different views, different epistemic paradigms with regards to the nature of competition. So not only factual adaptability, but also epistemic adaptability. And I'm also claiming that this ability is embedded in the law because of some key features of competition law. Competition law has a fuzzy mandate, as we already mentioned. It is aimed at protecting effective competition. And then we need to use expert knowledge from outside the law, economics, but various fields compose what we call economics, to interpret what effective competition means. The vocabulary is conceptually elastic: abuse of dominance, significant impediment to effective competition. Also, the law is deployed as a mixture of rules and standards. So we might have a rule, for instance, that there is a rebuttable presumption in the EU that an undertaking is dominant if they have market share above 50% in the relevant market, but we also have standards. See, for instance, post-Denmark 1, post-Denmark 2, all things considered, these rebates might be abusive. So the law is deployed as a mixture of rules and standards, and then we are using economics to articulate, to craft these rules and standards. And it wouldn't come as a surprise that economics do not have only a positive arm, but also a normative arm. We tend to think of economics as objective science, but this underplays or ignores a key element when it comes to economics as a discipline: the fact that there are different epistemic paradigms, there are different schools of thought. So based on the school of thought, we might have different benchmarks, different performance indicators, different legal standards. So if we just see economics as positive science and we disregard the normative element, we are actually making an epistemic mistake. But if economics are inevitably a normative science, an ideological science, then a law that heavily relies on economics, competition law, cannot but be open epistemically. So on this basis, I'm arguing that competition law is open, epistemically open, and also that is purposive. So we need to understand, or we need to debate and agree, provisionally at least, on a specific understanding of its purpose in order to apply it. There lies the responsiveness, the adaptability, the ability, to adapt to changing circumstances. Now, my point is that, especially in the context of the modern knowledge-based economies, responsiveness is quintessential in the law. So it's not only embedded in competition law, but it should be also a desideratum, an ideal we should be striving for. And why is that? I will not say much here, but we all know or we already feel that digital markets are a game changer. This phenomenon has already been studied to a large degree, and of course, it is studied and explored further, but they display certain features, such as extreme returns to scale and network effects. Digital markets are also the terrain where different new business models actually proliferate, such as multi-sided platforms, ad-based, that they operate on the basis of ad revenue. And then from multi-sided platforms, we see also the emergence of ecosystems and digital gatekeepers that can exercise not only market power, but also architectural power ecosystem power, and this changes the fundamental parameters of competition. So platforms might not compete on the basis of the price-based parameters of competition, price or output, but also on non-price-based parameters, or they might compete even for bottlenecks or for widgets that we don't properly grasp right now. So this means that we should harness the epistemic openness of the law in order to make sure that it's fit for purpose in this changing context. And this is of paramount importance, especially today when we are confronted with the limitations of conventional competition law. So conventional competition law, at least in hard cases, leaving aside cartels, for instance, which are there is no reasonable disagreement that should be presumptively unlawful. There is a serious controversy about almost everything, whether we should apply a presumption of lawfulness or unlawfulness, etc., etc. So the default method in competition law, in conventional competition law, is case-by-case analysis after market definition. Then we need to conduct a market power assessment and articulate a theory of harm that can suggest the existence of anti-competitive effects. But because of the different parameters of competition and because of the heightened judicial scrutiny, so for instance, the quite strict legal standards and standards of proof, there is a significant lagging. So for instance, there is also a significant concern that current enforcement might be doing less than what it should. So this is indicative also. This is something that can confirm this to a certain degree, is the European Commission's now attempt to rethink Article 102 by issuing guidelines, right? So the Commission, even though the guidance paper has been endorsed by the court, now is feeling that there is a problem of under-enforcement. Proceedings have become lengthy and costly and too cumbersome. So they are thinking we need to rethink the guidance paper and come up with something different so as to avoid under-enforcement. So with this, somehow I would like to conclude the first point, that competition law is inevitably responsive and we should harness this responsiveness. But even if someone agrees with me here that the law should be responsive, they might ask, how can we do that? So the short answer is that there are three different elements that should be combined to make the law responsive. The first element is engage in interpretive struggles. So when we apply the law, when an enforcer, a plaintiff, or a defendant applies the law, they should also develop a theory of harm that articulates clearly their understanding of the purpose of the law and the choice of an epistemic paradigm, and stress test this interpretation in the court. And then the court will be deciding which is fit for purpose for a specific period of time, because then the law is open, right? So then the court might change their mind, and they might change their minds and consider that there is another interpretation of the law that is more appropriate. So the first element of the responsiveness approach is to engage in interpretive struggles. The second is to enforce the law responsibly, and I will be focusing on that from now on. And the third is to understand the role of the courts, not simply as normal laborators. So enforcers go there, not simply, the traditional paradigm is understanding courts as normal laborators. We have a disagreement about the meaning of a provision. This is the input, the dispute. We feed that to the court, and the court gives us something, an interpretation. Courts are doing many more things beyond that. So arguably they operate as platforms where different stakeholders can test their interpretations of the law, so they can engage in argumentative struggles. And also courts can behave as responsiveness motivators, and they actually do behave as responsiveness motivators. So for instance, when an authority does not behave responsibly, the court has a mechanism to discipline them. So now, let me focus on, let's say, the main dish for today, which is responsive enforcement, right? So everything boils down to applying the law responsibly. And the basic idea behind responsive enforcement is that authorities should have at their disposal and make use of a pyramid of varied tools that would allow them not only to punish and deter, but also learn from the market and ensure compliance through persuasion. That's why the traditional pyramid of responsive enforcement is composed of softer tools, sunshine, and soft enforcement at the bottom, self-regulation. We are better off if we don't need to intervene, right? But then the pyramid also includes escalating threats. So tools of enforced self-regulation or harder tools, settlements, for instance, and also on the top, there are the so-called benign big guns, infringement decisions, right? Fines, sanctions, measures that are obligatory. And for the pyramid to operate, the enforcers have to have varied tools of varied intensity, but also they need to be able to escalate and de-escalate. So they should be able to use properly their benign big guns, and these benign big guns, right, the command and control forms of intervention should be deterrent enough. Otherwise, there will be no incentives to engage in self-regulation or enforced self-regulation. So then, if we look at the legal framework of various jurisdictions, we'll see that competition authorities have at their disposal multiple tools. They can engage in sector inquiries. They have comfort letters or letters of inapplicability of the provisions, so as to allow, for instance, private initiatives that might promote certain public interests. Then they have also commitments and other forms of settlement. So if undertakings, if firms seem to deviate from the law, but they are compliant at a later stage, or they are willing to comply at a later stage, there are mechanisms to ensure this compliance without immediately escalating. And of course, authorities have interim measures, settlements where there is a recognition of an infringement and infringement decision, right? The most, let's say, intrusive instrument. So already there is a pyramid of responsive enforcement. But something we should keep in mind is that the responsive enforcement is not only about having the tools, it's also about using them properly. Let me give you an example here. If, for instance, as a firm, that I'm willing to break the rules, I'm willing to take these risks, right? I, as a bad man, right? I make an estimate that the enforcers will be always gradually escalating their threats. So I will know that I will have them first a leeway. They will come to me and offer something to comply. Then we'll be negotiating a settlement or some commitments. And then maybe perhaps they will move against me. I have some space, right? Or I have some leeway for regulatory gaming. I can feed them false information. I can stall them. I can, in the meantime, exploit my position in the market to exclude rivals or achieve all my anti-competitive purposes. And then actual antitrust intervention will come too late and perhaps would be too little. So responsive enforcement, really responsive enforcement, this is also what the literature says, doesn't mean that authorities have to always gradually escalate the threats. They can also, and they actually should, make risk analysis and target analysis, build on past experience, and be able to rapidly escalate or even de-escalate. The de-escalation, for instance, could happen with commitments or remedies that include sunset clauses or limited duration. two more elements are elements of a responsive enforcement strategy. The first one I have there, it's they call it in the literature tripartism, but it actually has to do with learning. So for authorities to be responsive, for authorities to harness the epistemic openness of the law, they have to learn, right? And how can they learn? They can learn from the market. How can they learn from the market? They can learn from the market through mechanisms that organize negotiated solutions. For instance, commitments of Article 9 of Regulation 1/2003 allow the Commission to conduct a market test, so invite stakeholders and complainants to bring information about the potential behavior, the potential violation, and also bring information on the remedies, right? So the undertaking under investigation might offer certain commitments, certain remedies to address the potential problem. And then during the market test stage, other players will jump in and will feed some information. And then the Commission will have the opportunity to learn. And the fourth element of a responsive enforcement strategy has to do with reflexivity. So authorities have to assess their performance on the basis of benchmarks and key performance indicators. This was the case, for instance, in the parity clauses in the online hotel services in Europe. So there, the Commission, together with other competition authorities, used commitments to address the problem. After this enforcement action, they conducted a study to see whether the adopted measures, the adopted remedies achieved something. So then they had to reflect. The benefits were marginal, just for the sake of the story, but this is already shows some reflexes to consider, to reassess their performance. And the Commission actually does that quite regularly. But when we talk about reflexivity, it's important to keep in mind that we do not only refer to review your performance based on your key performance indicators and benchmarks, but also review these benchmarks, review these key performance indicators, right? Are these still fit for purpose? This is how you harness the epistemic openness of the law. So now let me, again, if you have any questions or comments, I don't know if you, because I cannot monitor the chat, feel free to jump in. Okay, so now let me give you some examples of what I would consider successful or less successful responsive enforcement. Let's start with the famous Google shopping case. So Google was starting to become dominant in the search engine market from early 2000, and it saw also that there was an adjacent market, the market of comparison shopping services, that was nascent and quite promising. So in the beginning, they had Frugal and their own shopping service up. Eventually, by 2007, if I'm not wrong, they modified that. They tweaked also the algorithm, and they modified the model that actually made them successful. So they engaged in the following behavior. They started promoting their own comparison shopping service and demoting to the digital Siberia of page 4 the comparison shopping services that they didn't like. Of course, at first glance, there is nothing bad with this kind of behavior. But as you can see also in the decision, the court noted there that the market had already tipped, and because of network effects and because of Google enjoying a super dominant position, it could seriously harm choice and innovation in the market and actually foreclose its rivals by engaging in this composite behavior, promoting its own comparison shopping service and demoting the rival. So this was considered by the court abusive leveraging, not self-preference, abusive leveraging, and was found to be a violation of Article 102. But what is interesting in this story is that the commission, before issuing its decision, it spent several years to negotiate compliance with the company. These attempts to commit failed. After that, the commission came up with its decision and imposed a ostensibly skyrocketed fine, and obliged Google to abstain from this kind of behavior. But there is a problem there. If we look at the remedy, the decision said we should abstain from behavior that we consider as violating Article 102. What is this behavior exactly? Promoting and demoting. Okay, how can I address this problem? What could be the appropriate remedy? So after several rounds of commitments, of attempts to commit, and after a lengthy investigation and an infringement decision, we were not clear about what would be the appropriate remedy. Is that satisfying? More than that, we spent several years for this investigation and the decision. And of course, the case is still ongoing because the General Court sided with the Commission, but of course, Google has appealed. And everyone perhaps was impressed that the Commission imposed a 2.6 billion fine, so a skyrocketing fine. But if we look closer, we'll see that this fine corresponds to 6 days of Google's operation. So in the meantime, this antitrust investigation lasted more than 10 years, 11 years, and the market changed. So where are the price comparison shopping services now? Now, let me take you, and just to make clear, a takeaway here that I will be repeating towards the end is that escalating gradually might not be always the best course of action, right? Might not be always the most responsive enforcement strategy. Now, let me take you to a less sober story. So in 2021, Amazon, the Commission issued its statement of objections against Amazon for the following behavior. So Amazon was combining data collected from different sources in order to leverage its own services or affiliated merchants. And also Amazon was using the buy box and the Prime service in order, again, to self-promote, right? To engage in what we call today self-preferencing, promote its own services or products or affiliated merchants and downplay or not promote the others. Within 2 years, the Commission managed to secure commitments in this case. So Amazon promised, and the duration of commitments was 7 years, not to combine non-publicly available data collected through its different businesses. It also promised to treat all sellers equally and to not engage in discrimination. It is important to note here also that the main problem of the Commission was not an output restriction or a price increase. So the commitments, of course, the commitments do not include the finding of an infringement, right? But the company will not make such concessions that change their business strategy and perhaps also business model unless there is a threat, right? So unless there is a threat of being found violating Article 102. But here, the Commission did not really argue that Amazon's behavior amounted to a restriction of output or to a reduction, to an increase of prices. The problem that the Commission took issue with was that Amazon, due to its structural advantage, due to its dual role as marketplace and retail, for instance, could control the e-commerce process in its platform, pick winners and losers, and also cap their ability to compete. So these kind of concerns do not squarely fit the traditional or conventional consumer welfare model that is attached to the crime tort enforcement style. Now, let me take you to another story that I would consider a successful story of responsive enforcement, but not on terms of speed, because here in the Amazon marketplace, just before, we saw that enforcement was speedy and sufficiently effective, right? But now this case is about something else. It's about clarity. So responsive enforcement should also be about bringing clarity in the market. And clarity in the market can be secured not only by infringement decisions. It can be also secured by software instruments if these are used properly. So in 2010, 2011, the Commission was confronted with the following question. Can a holder of a standard essential patent that has committed to grant licenses on front terms abuse their dominant position by seeking through an injunction to enjoin the implementation of technology that is related to the standard essential patent? So this kind of question was at the heart of the patent wars between different smartphone manufacturers. So different manufacturers had secured SEPs, and then they were using strategically the SEPs to block their rivals from accessing particular markets. This is a rather complex question, and the court had not spoken on it. There was no clear case law, so the Commission was on thin ice, one might say here. The Commission issued these Samsung commitments where the company agreed not to seek injunctions and to engage in already designed, dictated by the Commission, negotiation process with licensees, because the Commission said that seeking injunctions, even though generally legitimate in the context of SEPs, standard essential patents, may constitute an abuse when the rival of the SEP holder is a willing licensee. So the willing licensee test that the Commission articulated there in the Samsung commitments was that if there is a willing licensee, so if there is a rival that is willing to pay royalties, then the SEP holder will be abusing their position if they file for an injunction. And if they have a disagreement on the amount of royalties, the Commission dictated the choreography of negotiation and also obliged the parties to hire a third party, an arbiter, to demonstrate, determine, the amount of royalties. So the Samsung commitments brought clarity to the law, even though they were a soft law instrument, right? So commitments, again, do not involve a finding of an infringement. And if you see, just a couple of years later, the court issued Huawei, and Huawei deals directly with this question. This is the question of the decision. And there, the court simply rubber stamps the Commission's approach. So we already knew, let's say, the law, we already knew what to do at the time the Samsung commitments were issued. So here we see also a successful case. Let me now move to, I don't know how much time I have, one more case that can demonstrate that when we talk about responsive enforcement, we are actually talking about an overall strategy. So responsive enforcement means that authorities need to devise an overall strategy to intervene in the market and not simply think on like one-shot terms, one-off terms. So in the 90s, energy liberalization was a hot topic. So the European Commission was trying to liberalize the market, to dissolve legal monopolies. So the first energy package was adopted, but the energy incumbents were fiercely resisting. Then the second energy package was adopted, but still we're far from achieving our purposes. So at that time, after the second energy package, the Commission launched a sector inquiry and opened several antitrust investigations for violations of Article 102 by the energy incumbents. So most of these investigations closed with commitments. Only two, actually, from the 25 investigations closed via an infringement decision. These energy commitments were triggered and they were based on the findings of the sector inquiry report, right? Sector inquiry report, then we have commitments. And most of these decisions, they involve traditional theories of harm. So for instance, tying through long-term contracting or refusals to deal or magic to squeeze, but also some of them, they involve controversial theories of harm. So for instance, a refusal to supply theory of harm was based on withdrawing capacity or strategically underinvesting. This was quite controversial, but the company, Eni, agreed to divest its assets to avoid the finding of an infringement. So there we see that the Commission managed to secure not only behavioral, but also structural remedies. And it did that because the commitments came as part of an overall strategy to liberalize the market and inject competition. Now, let me close my case studies discussion with a UK entity. So in the UK, there is a tool that we call market investigations. And this is quite an outlier in antitrust enforcement because it seeks to address market failures regardless of a finding of an infringement. So there is no penalty for past behavior and there is no actual antitrust violation, but the authority will conduct, for instance, a market study. Usually this is what happens on most occasions, even though they are not obliged to. They will conduct a market study and they will identify certain structural and behavioral elements that would be suggestive of adverse effects on competition. And on this basis, they can impose remedies. So you can understand that market investigations can be a pretty frightening, a pretty intrusive instrument. Yeah. And you see also here that market investigations have been used extensively and in various sectors. So with this, I just want to close with a few thoughts on how competition authorities and forces could behave responsibly or more responsibly. So first of all, we see that responsive enforcement does not only require a variety of tools, but also their coherent and effective use. It requires also escalating, de-escalating quickly, rapidly, or gradually based on a risk analysis or a target analysis and a market analysis. So it also requires some imagination and experimentation with regards to remedies. And also it requires devising overall enforcement strategies based on sectors. The other thing that responsive enforcement requires is focusing on problems. How could we solve the problem? Not simply establish a legal violation, see the Google shopping case. What is the actual problem and what would be the remedy that can address this problem? On this basis, the responsive enforcement also might incentivize or require co-creation of remedies and input from third parties. So for enforcers to behave responsibly, they need to learn How? By doing, so they can learn by using also software tools or third-party negotiations, but they can also learn from each other. And this happens in the context of EU competition law through the European Competition Network. And enforcers, this is what the responsive enforcement theory says, should care not only about punishing and deterring, but also about persuading and ensuring compliance, and about securing the public's perception and awareness with regards to the implementation of the law. This can also be secured if they exercise their discretion effectively, but they exercise their discretion through procedural safeguards. So the authorities have to also be careful and vigilant to, let's say, self-impose, right, procedural safeguards to avoid claims of discretionary remedialism. And two last points are relevant here. When they deploy their policy, authorities should be mindful not only about regulatory compliance, and many authorities have guarantees and checks against this kind of problems, but also about capture. This is the word there. I made a mistake on the slide. So this ties up with what I was saying before about the epistemic openness of the law. So authorities should be also reflective and consider whether the epistemic paradigm they are endorsing and they are enforcing actually is fit for purpose. And last but not least, authorities should not use software tools to appear responsive, but actually to avoid judicial scrutiny. Because as we see, courts play a role of paramount importance in recalibrating the responsiveness of the system. So authorities, when they have a pretty controversial case or a case where clarity is quintessential, they should not take the easy road, but go and test it before the courts. This is it, and I'll stop here. Thanks a lot for your attention.